we have a special session for us. Today we're going to cover the topic of transfer of underlying basis. The common questions and answers that we received from the people, though. We're getting a lot of calls, a lot of queries, a lot of things. So we want to answer some of those questions. This is to achieve switching from EB3 to EB2. Emily, anything you want to discuss?
Yeah, so let's kind of start from the top. What is transfer of the underlying basis? It is not a new concept. This is something that's been around for decades, but we have a new way of doing it, and it's become more important for people now compared to in the past. So anytime someone has multiple grounds for receiving the green card, meaning multiple eligibility categories, and they may have filed the 485 based on one, and then a different category might be more advantageous or beneficial or faster, whatever the case might be, they have the opportunity to change their category from the old one to the new one without having to file a second 485. Now, I know a lot of the people that did the whole downgrade dance back in October 2020 ended up refiling, and that was successful for a lot of people to get a faster approval. But for those that didn't refile, your other option is, instead of filing a second 485, to request USCIS to transfer the underlying basis from the previously submitted EB3 I140 to a newly submitted EB2 I140. This could be an I140 that you had from way before, or it could even be a new one. A lot of people that had changed jobs in October 2020, while they were working towards the green card with their old employer, they were also filing a new perm with their new employer, which of course was taking forever. And now those people might have a new EB2 I140. Yes, you can transfer the underlying basis to even a brand new I140 as long as the final action date is current. So it's not anything new. Now, before January 2022, what was the procedure to do a transfer of underlying basis?
We used to send a letter to USCIS indicating that this guy has an I-140 approval under EB2, and we used to send a notification to the USCIS to consider us under the EB2 application and approve it. Now, there are some situations where we have done otherwise also, Emily, especially for Chinese nationals. When the EB2 moved backwards and EB3 moved forward, we did otherwise also from EB2 to EB3, though. Obviously, USCIS came up in January of 2022 saying that if you want to do the transfer of underlying basis, do it with a 485J supplement. They have given a particular address in California to send to these applications. It was very surprising for us because in this they asked us to send to a California address where there's no service center especially that is adjudicating the application. But initially we were a little bit skeptical when we are sending the 485J supplement. Obviously we followed the directions and a lot of the cases got approved, Emily. But here is the common questions that pop up, mainly, Emily. You know, if the person has downgraded from EB3 to EB2 in October of 2020 with company A and is still working with company A, I mean, it's easy, slam dunk. They are filing a transfer of underlying basis, sending it to the California address, and everything is going through smooth, though. But here is the multiple scenarios that I want to ask questions to you. The company A that he's working with has only EB3 approval, never had a EB2 approval, filed a 485, but he has a previous company's EB2 approval. Can the company A, which is working, use company X I-140 approval to do the transfer of underlying basis?
Well, I think USCIS and their guidance would say no, that shouldn't be allowed unless the old company is intending to submit the supplement J and has that job offer available.
But they didn't say no in their instructions.
Right. So they're telling us that we need to have this supplement J from the company that filed that I-140 in order to verify that the job offer is still there, the company still exists, and you intend to take that job. But in reality, they're on their own pulling that EB2 I-140 from the old employer and saying, here you go, well, here's your green card in EB2, when no one even asked them to do that. And we got very nervous in some of these situations thinking this doesn't look right based on their guidance. So we reached out to USCIS to figure out, hey, was this approved in error because he's not with this company and wasn't intending to transfer the underlying basis. And they said, no, we have the authority to do this. We did it on our own. this was not approved in error, so the EB2 was fine.
So let's understand. I filed a 485 with company A, which has only EB3, and company X, my previous company, has an EB2 I140 approval. Are you telling the USCIS just approved it?
Mm-hmm. And confirmed that it was not approved in error.
This was very surprising to us, guys. I mean, this was not a creative idea that Reddy Neumann PC is coming with. This is the USCIS is telling us that they have an authority to it. Not only that, we have received so many RFEs to the individual asking them, hey, buddy, you have an EB2 approval with company X. Why don't you use that to get the green card because it's current in the EB2? And we have filed so many of those 485J supplements with company B and got those things approved. No problems with it. Absolutely. Now, we also got some RFEs where they only are asking the employee to request a transfer of underlying basis without any 485J supplement. They are telling that, look, buddy, Srinivas Rao, you have an EB2 approval with company X. Why don't you write a letter to us that you want to use the company X I-140 approval? That's called transfer of underlying basis. And we are sending the letters and we're getting the green card approvals. And initially when green cards came approved without us requesting the EB2, we were very surprised. Emily and we were very surprised. And we started questioning the USCIS, and that's where they come up, that they have an authority to that. And they have given us all these things and we started using it. Things are working perfectly all right. Now, Emily, when it comes to, they come up with a rule called 180-day rule. 180-day rule, that after you file the 485J supplement, are they following the 180-day rule?
No, not at all. I mean, if they were, then they would not be allowing people to utilize their new employer submitting a supplement J with their old employer's EB2 I-140 approval. But even in the RFE, they're telling you, do this. This is what we want. So although, yes, they did say that once you submit a supplement J to transfer the underlying basis, you cannot change employers again and submit another supplement J for 180 days. The 180-day portability clock starts over. They're not actually following that because they're allowing people to utilize the old company's I-140 approval without the old company's supplement J. And so oftentimes what the most common situation that's been coming up is you have your I-140 and EB2 with company A, you did the downgrade with company A, you got that EB3 I-140 approved, and now you've moved to company B utilizing AC-21 based on your EB3 485 that has been pending for more than 180 days. Now the question becomes, can company B submit the supplement J? Yes, they can, because you've had your 485 pending for 180 days, but can they reference your EB2 I-140 approval because of that 180-day rule? And yes, they can. USCIS has been telling us to do that. They've been doing it on their own. When we've requested them to do it, they've been approving them. So that is a good news. It allows people to take advantage of their old EB2 approval, and even though they've moved on to the new company, which makes sense. The whole idea of AC-21 was to allow this portability, to allow people to change jobs after they had reached the 180-day mark of their 485 being pending. It makes no sense to now say, oh, you can't rely on any other category once you have moved to this new company.
Emily, if there is an RFE asking them, pointing out to the 485J supplement, and they're pointing out to the previous company's I-140 approval, the previous company is not cooperative, the current company is not cooperative, what is the course of action?
Yeah, I think in that situation, I would reply back requesting, I mean, when you say the current company is not cooperative, you mean they're submitting the supplement J but referring to your EB3
That is
approval.
right,
So
right.
They're willing to submit the supplement J,
Yeah.
but only referencing the EB3, which you clearly qualify for
Yes.
AC-21.
Yes.
So in that situation, obviously USCIS is requesting a supplement J. They need to see that you have a valid job offer that supports the 485. So you do need to get that supplement J from that employer. But while you're responding to that RFE, you can also submit a transfer of underlying basis letter. It's a written statement by you that simply says, I have an approval in EB3, this receipt number. I also have an approval in EB2, this receipt number. Please adjudicate my 485 in EB2. That's all you're requesting. At that point, it's in the hands of the USCIS officer to decide whether they're going to keep you stuck in EB3 because that's what the supplement J says, or put you into EB2 based on your request to make that transfer.
Yeah, there are sometimes, Emily, the company's lawyer is not willing to attach that letter that the employee is giving, but we still want you to respond to the RFE with your company signing the I-485J with the EB3, and then later on separately you can send a note for the transfer of underlying basis, because if they don't see the 485J supplement, your 485 will be denied. And you can always send a private note to them saying that, look, consider me under EB2. As Emily pointed out, it may work, it may not work, but it won't harm you under any circumstances. And it's better that you respond to this as quickly as possible. Emily, why are these, why initially when we started seeing the USCIS approving EB2 application when we filed in EB3 with the previous employers I-140, why are they issuing RFEs right now?
Why are they issuing RFEs?
Right. Previously, they were not issuing RFEs.
Right. Yeah. I mean, their own guidance says that they need a written statement from you and that they need the supplement J. So perhaps now they've decided to follow their own guidance and make those requests rather than just doing it on their own. But they do have the authority to do it on their own, or they could send a request so that they have something in writing from you making that request.
One of the other thing what some people did, Emily, is they filed a motion to reopen for the approved green card applications. And these are the things that created problems for the USCIS. That's the reason why they are requesting. Otherwise, they could have just approved all these cases without troubling us and without doing anything.
Yeah, and people are contacting USCIS 2-3 different times about this to make sure everything's fine with this green card. They think it's in the wrong category, and they're getting a different answer from every single person they talk to at USCIS. Again, we've verified this in our own cases because we thought it was a mistake at first. USCIS confirmed everything is fine. So as long as you qualified for EB2, the final action date was actually current when they approved it. I don't see any reason to contact USCIS multiple times to double check and triple check that everything is correct, or even file an MTR. I would not do that.
Emily, the questions that are coming about the I-485J, once that's been filed, and I move out of the company within 180 days, what are the consequences though?
Yeah, so USCIS suggests again that you have to wait 180 days before you're eligible to port again to another company after submitting a supplement J. That doesn't mean you can't move to another company. It just means worst case scenario that you're going to continue in EB3 because you've qualified for portability with respect to EB3 since probably May 2021, 6 months after you filed your 485. You qualify to keep moving. You could move the job every day if you wanted to and still qualify in EB3. The only question becomes, can you still utilize EB2 if you port again within the 180 days? And the answer to that is, if they decide you're not qualified for EB2, they're not going to deny the green card for that. They can't deny the green card for that. They're just going to say you continue in EB3. So there's really no downside to it. You're already in EB3. You're just going to end up back where you were.
Oh, some of the employers, Emily, when they move to a different company, they're telling to withdraw the 485. Should they withdraw the 485 because they moved within 180 days after filing the 485J?
Definitely not. No.
Oh, no.
No.
And there are some of the people who got the green card, their employer is telling to file a motion to reconsider. Should they?
No, definitely not.
Okay. Please don't give up your green cards, guys, unless you consult a proper lawyer. Some of these people they're just trying to make more money for. That's the only reason I can think about it. USCIS is telling that they have an authority to approve the green cards. So don't fall into these people's trap, though.
Yeah, another common question I get with the supplement J is a lot of these things end up crossing in the mail. So maybe a week ago you submitted your supplement J to transfer the underlying basis, and the next week your green card gets approved. Well, did they actually get your supplement J on time? Did they process it? Probably not, because the approval happened too quickly. Does that mean there's a problem? Do you need to contact them and say, hey, I need my supplement J? Does that mean you have to wait 6 months to change jobs after you've already gotten the green card? No, remember the supplement J is not an application. It's not something like a 485 or an I-140 or an I-129 that you file with USCIS and they have to give you an approval on in order for your status to continue. The supplement J is a confirmation of a bona fide job offer or job portability. It's just the way for USCIS to capture the data about the job offer and verify that it exists. Now, do they issue approval notices? Yes, but if you don't get an approval notice or if you don't get a receipt notice, that's fine. You don't need it for anything. There are attorneys telling people, we need to wait until we get this. We need to make sure it gets approved. You can't change jobs until you get your supplement J approval. You're already a green card holder. You can do whatever you want at that point. Yeah, so don't worry about the supplement J.
Emily, what if they issued RFE only on the medical examination? Should I respond request with the transfer for underlying basis if I've not requested it?
Yeah, I definitely would if you qualify for it. And even if you can't get the supplement J from the company, if you're not cooperating, either the old or the new, go ahead and make that request on your own. There's no downside to it. It's in USCIS's hands. They can decide whether to, agree with your request or not, but there's no harm in making that request as part of the RFE response.
Emily, I have received my green card, but my 485J is not approved. Should I give up my green card?
No, definitely not. Again, the 485J approval is completely irrelevant. You got your green card, that's the approval that you need. So don't worry about these 485J receipts and approvals. Once you have your green card, none of that AC-21 rules apply to you anymore. Now you're a green card holder. You can follow the rules that apply to green card holders, which allow you to work for any company.
Okay, my request to you guys is that if you have not interfiled to EB3 to EB2, if you have any EB2 I140 approval, this is the time for you to do the transfer of underlying basis. If you don't know, you check with the lawyer. If the lawyer is not agreeing, check with a different lawyer who knows how to do the transfer of underlying basis, who have dealt in the transfer of underlying basis. So please don't wait on the sidelines. If you have not refiled the application, if you have not interfiled to EB3 to EB2, you ever have any I-140 approval in EB2, you should contact a lawyer to do the transfer of underlying basis. With or without your employer. There are two options. With your employer is obviously better option compared to without your employer, but don't be on the sidelines right now, because this is a chance where you may be where you have a good chance of getting the green card before September 30th. You may lose that opportunity if you don't take it.
Is that something that you can help with if people need that?
Yes, especially in our office, there's also Juanita. That's a lawyer. It starts with J. Can you spell it?
Juanita.
Juanita. She's a very good lawyer. You can contact her, Emily, me, or Rebecca Chen. Any of us will be fine. But she's more. Juanita is the one who does these things in our office more than anybody else, though.
Yeah, and what other questions do we have here? Why is it so important to get the approval by September 30th if you have that option in your hand? You know, yes, we're going to get the next year's green cards are going to come out. We don't know if the dates are going to move forward or backward or stay the same because we don't know how many green cards USCIS are going to be approving. It looks like they're going to hit the 280,000 mark. We don't know how many people are left over after that to where maybe they took in too many applications and can't move it far forward. We don't know how many family-based are going to spill over. What we do know is in the first quarter of the fiscal year, their processing of employment-based 485s goes in the tank. They'll probably approve 5,000 applications in 3 months. Yeah. In the second quarter, they will do the same thing. And in the third quarter, they will do the same thing. And then in the fourth quarter, they might get around to your application if they didn't approve it in this fiscal year. So although they can still approve it next year, the issue is their processing right now is the golden opportunity where they're working hard to approve as many as they can. And once you miss that boat, we're back to they're going to take forever. It's going to take 3 quarters. They're going to just process them as slowly as they can until they get, letters again from congressmen and senators and people telling them they need to hurry up.
Emily, what if I moved from company A to company B? Company B already filed a 485J supplement using the EB3 I140 application. Can I still now file with the company B, with using EB2 I140 application?
I don't see why not, because they're based on the exact same labor certification. So yeah, give that a try. If company B is not willing, then file your own transfer of underlying basis by sending in a letter.
And if your company B is telling that, look, that I-140 doesn't, EB2 I-140 doesn't belong to me, hey, when you file the 485J supplement first time, whose I-140 you used? The whole 485J supplement porting it to one company to another company is using the old company's I-140. The EB3 I-140 doesn't belong to company B, it belongs to company A. You use the same thing. Why can't you use company A's I-140, which is approved in EB2? You already used it in EB3. Give them the logical question to them if they're not cooperating.
All right, I think we're good. Did you want to take questions from the live audience? Or?
I think so. We took the questions. Let's see if you have any questions. Most of the questions are related to how fast the green card can be approved. The way the process is working right now is after we file a 485J supplement, in about a week's time to 2 weeks' time, the case is getting transferred to National Benefit Center. Then it gets adjudicated, though. They are really moving it as fast as they can. I mean, as fast as they can. They are approving a lot of green card applications right now. We don't know how many are left. So it depends on how many are left. We may still see a lot more approvals by the end of September 30th. But we are seeing a lot of approvals.
Mm-hmm. And what should someone do if they filed in October 2020 and their case is just sitting there, they're not seeing any action? Is there, assuming their EB3 I-140 is approved, assuming they've submitted their medical, assuming they've done the transfer of underlying basis, should they be contacting USCIS? Should they be chatting with Emma? Should they be contacting their senator?
What I noticed is when they're doing all these things multiple times, though, the file is getting pulled out here and there. It's not doing anything. That's what I'm noticing, though. Since it's not crossed the processing time, contacting Emma won't work, contacting the Congressman won't work, contacting the Ombudsman doesn't work out. What I normally suggest people is when it is approved for the main applicant and for the dependent it's not approved, that's when I normally tell them to contact the Ombudsman or contact the Congressman.
Yeah, I think your only other option besides waiting is litigation. And if that's something that you're interested in, our office can help with that.
Yeah,
but you're at that stage where it might not be, you might get the approval without it. So,
that's one thing. And then maybe even if you file a litigation, what if in October the priority date moves back? Mm-hmm. Then definitely we'll have to withdraw the litigation, so that expenditure will be wasted. So definitely I would wait until October to see how the things are moving, and based on that, I would go to litigation at that point of time, but not right now. Anything else, Emily?
All right, I think that's it for today.
Thank you very much for tuning in, guys.